Call our last case of the day, People versus King. Just a minute. Good afternoon, Council. As I said, this is a 15-minute mini oral argument on the application. You have a 2-minute free fire zone, and you may reserve time for rebuttal if we do not use it all up.
Good afternoon, Your Honors. Jacqueline McCann from Sato on behalf of Frank King. I'm joined at council table by co-counsel Jessica Zimbelman. I will try to save at least 3 minutes for rebuttal. Your Honors, today we are asking the court to stay the course for almost 50 some years, since 1976 in Anderson. The court set in place a system for what is required for a valid waiver of counsel. In 1996, you modified it with the substantial compliance aspect, but in every case where this court has evaluated whether or not there was a valid waiver of counsel, you have not applied the forfeiture doctrine. You have not required there to have been, from that then self-represented party, that person to say, hey, judge, I don't think you've quite done a good enough waiver with me. Let's do it again. And there is no reason for this court to back away from that basically 50-year history now. So we're asking the court to direct the Court of Appeals to stop overruling your precedents by implication, or finding that you have overruled them by implication, and apply. They've been applying Carinas to essentially everything under the sun since it came out. We know from what Justice Zara did in Hawthorne when he was Judge Zara on the Court of Appeals, that the proper way to do that is to ask this court if it means to extend Lucity and Carinas into another area, and give that option to this court to overrule its own precedent. But going forward, why shouldn't you? Why shouldn't you apply the forfeiture doctrine? Because every time, because the right to counsel has been found to be one of those rights that is self-preserving and non-forfeitable, because it is fundamental and foundational to our system of justice to effectuate all the other trial rights and other constitutional rights of the defendant and make them have a meaningful interaction with the system. If one area I do want to expand on that maybe I didn't discuss enough in the brief, I've argued that counsel didn't act as full counsel at the plea hearing. Even if this court disagrees with me and finds that that counsel acted as full counsel at the plea hearing, or that somehow the plea hearing itself is valid, that does not cure the deprivation that occurred in terms of Mr. King being at trial after an invalid waiver of counsel, representing himself, getting so frustrated that he gave up. That doesn't make it less of a deprivation of counsel because trial didn't go to conclusion. In my mind, that makes it...
He had advisory counsel then as well, right?
He did have the same advisory counsel. We do have the transcript now of the trial. Counsel did as advisory counsel is supposed to do at trial with a self-represented party. He didn't interfere because, of course, that other danger, because it's the dual nature between the right to self-representation and the right to counsel.
Yeah, your client invoked his right to self-representation, right?
He did, Your Honor, and by motion. And I also want to say that the fact that he did it in writing rather than just orally, this court has never found that receiving a written motion means that the trial judge doesn't have to have that personal assessment in court.
No question the judge didn't do it. Same judge, by the way, in your other case, Mr. Simon, who's a very good judge apparently, although he made miss these two issues. But, you know, as I told my law clerk, I guess it's only fair to say to you, only in a conversation amongst lawyers would we be talking about a defendant who had, what, 2 or 3 court-appointed lawyers, and he fired them all and fired the third one and told the judge in a written motion that he wanted to proceed on his own. Only amongst lawyers would we be talking about that as a deprivation of counsel, right? If you talk to a person on the street, they'd say, wait, he had 3 lawyers at the public expense that I paid for, and he said he didn't want a lawyer, and now he gets a new trial?
I don't know that I completely agree with that, Your Honor, in that the public is so trained by Law and Order and various shows that they'd probably say, hey, that guy's crazy to try to do this
Well,
on
there's
his
no
own,
question,
but-
it's not a very sound decision, but he, the lawyers weren't taken from him. It's not a situation where he couldn't afford a lawyer and one wasn't provided, or that the judge said, sorry, you're not getting a lawyer, that kind of thing. It's just a pure, the waiver procedure wasn't followed, right?
I would say we very often have that, like, this circumstance is certainly less egregious than the conduct of the defendant in, say, People versus Russell, which is less egregious than the conduct of the defendant, say, in People versus Lewis, where, there is a very hostile, openly hostile relationship with counsel. But to some degree, not to get too far off topic, a lot of these cases where they ask to represent themselves grow out of the fact that, we don't have standard 4. We don't have any form of hybrid representation in the trial court. If judges would just hear their unmeritorious pretrial motions and take a half hour to deny them, we could then go on with counsel. But that's for another day, I suppose.
Couldn't it be argued that perhaps that conduct, the history that Justice Fabiano laid out, and perhaps in more egregious cases, is perhaps the very reason why we want to make sure that somebody like the judge is fully informing somebody who perhaps isn't making the best choices of the consequence of the choice he's about to make?
Yes, that is why the court set up the court roll, and so they know with eyes wide open what they're facing and the dangers of self-representation. Again, taking this back to Mr. Lewis, Mr. King certainly can't be put in a worse position than Mr. Lewis was. Mr. Lewis's deprivation was at the preliminary examination. He was represented by counsel at trial, and under the U.S. Supreme Court precedent and this court's precedent, that wasn't enough. That, quote unquote, fair trial wasn't enough to say, you're automatically denied relief from the pretrial deprivation. So here we're at the actual guilt determining portion, the trial, he's without counsel after an invalid waiver. At the very least, he would be entitled to that, if not structural error, which we do believe for the reasons in the brief that it is structural error, but you certainly can't be put into a forfeiture position any worse than Mr. Lewis got a remand for a determination of harm under the preserved constitutional standard, harmless beyond a reasonable doubt. And if the court has other questions, I'm happy to answer them, and other than that, I'd save my time for rebuttal.
Thank you.
Good afternoon, Your Honor. Once again, Emil Sama on behalf of the people. And once again, looking at a transcript, banging my head against the wall. I will at least let you know, while not part of the record, this particular judge from the last 2 cases has, since these cases, changed his policies and now gives amazing records on all kinds of things, thank God.
Your office could help out a little bit, too, by
we have
pointing
been.
out to the judge
There's been some
what type of
assistance in that
findings
matter.
and hearing are required, let's not forget.
But this case lends me a unique situation, and it reminds me of an old saying, if a tree falls in the woods and there's no one around to hear it, does it make a sound? If a defendant even though there's no question that if this case had gone all the way to trial, with this waiver on the record such as it was, he'd be entitled to a new trial. You'd see a concession out of me, and there'd be no real reason for us to be here standing in front of you. But we have a unique situation, a unique procedural situation that doesn't occur usually in the situation where the defendant took a plea that his advisory council worked out for him and helped put on the record and went through his rights. So it kind of comes into the question of when you have that situation, when you have somebody who enters a knowing and voluntary plea, does that challenge or change any errors that may have happened in an aborted trial? And you had that a lot of times, right? Imagine if you had counsel doing the trial and there was some initial question of a witness and they want to argue ineffective assistance, but in the middle of the trial, the defense had to enter a plea. Does he still get to argue ineffective assistance for a trial that ended at his request to enter said plea? I think that's what you have here. So you have here where you have the defendant stopping the trial, and I know Sister Counsel said so frustrated he gave up, but there's no record evidence of that in any way, shape, or form, which would go to my recommended remedy if we have to go that route, that there's no remedy that he was frustrated, that he entered into a plea agreement, a Cobb's negotiated by his counsel, Mr. Haddad, went on the record, went over his rights, went through all the rights, went through the colloquy, and Mr. Haddad said the court complied with 6.302, advised him of his rights, the whole chit and caboodle, basically, that he went through and represented him as his attorney, even if he called himself advisory counsel, in this plea colloquy. So then the question comes down is, what is the standard of review? One, I would argue it would be a plea withdrawal standard of review. However, if the court wants to combine the two situations together, I think the proper standard of review for at least would be under People v. Davis, the enunciated rule regarding the modified plain error test. And under either situation, the remedy here is not automatically a new trial, but at the very least for one, a remand to determine whether or not his plea was knowing and voluntary, because they can argue that he was so frustrated he gave up at the trial and wanted to enter a plea, but there's no evidence of that. Or two, if we're using the Davis standard, then the prosecution should be allowed to rebut the presumption, the rebuttable presumption standard under Davis. And because this case, both the Court of Appeals opinion and everything that happened long before Davis was enunciated by this court, I think we should be allowed to at least have that under either standard. To automatically say that structural error and he's automatically entitled to a new trial, even though he entered a plea, I do not believe is what should be the rule from this unique procedural posture. That's what's unique here, is the procedural situation that occurred here. That you had jury selection opening in the middle of the first witness, and then he enters a plea. That's what we have, procedurally speaking, in this case. Is it important that trial court go through the rights? Absolutely. Does that change when the defendant ends the trial, goes into a plea, and has counsel who effectively represents him during that plea, gets him a Cobb's agreement, and goes through his rights? I think now at that point, he'd had counsel during a critical stage of his proceedings. And Mr. Haddad could refer to himself as advisory counsel all he wants, but if it walks like a duck and talks like a duck, he's the attorney. Unless there are any questions, it's been very silent. Okay, then. I will leave it there. If there are no other questions, thank you, Your Honors.
Thank you.
Thank you.
Thank you, Your Honors. Briefly, I think the concession that had this gone to verdict, he'd unequivocally be entitled to a new trial is fatal to their position. And I disagree with Brother Counsel's characterization of the record. I think it's clear that he gave up after the prosecutor, acting as a minister of justice, asked for a recess, had the jury excused, and explained to the defendant, with the help of the judge, that, hey, your cross-examination, you've opened the door for me to admit otherwise inadmissible prejudicial evidence against you. After that, they take a recess, he comes back, and he says, well, let me just have that plea. Let me just have that Cobb's. In the realm of what could... The point about ineffective assistance of counsel has never been found to be a structural error. It's always required the defendant to show a reasonable probability of a different outcome. This is a different animal, it's structural error. The fact that the trial was stopped and he entered the plea is no different than if he had taken it to verdict. He's entitled to relief. He was denied counsel at trial. He suffered consequences because of that, and the guilt determination was entered after that. Again, the difference between this and Lewis is, in Lewis, it was a prelim. It's not the guilt determination proceeding. So the court does allow that beyond the standard for preserved constitutional error was the error harmless beyond a reasonable doubt. The court did allow that for that pre-trial preliminary examination. This is the trial and or the plea, the guilt determination phase. That has always been found to be structural error, whereas there is a denial of counsel, and we ask the court to stay the course. They've offered you no reason to overturn your existing precedent and your existing system, and under stare decisis and for the other reasons in the brief, you should not. Thank you.
Thank you. The case will be submitted, and the court will stand adjourned until tomorrow at 10 a.m.